everyone. Welcome to another session of Let's Talk Policy. I'm Smita Sharma. I'm an independent journalist and a visiting faculty at the Kautilya School of Public Policy. Each month, we try and deliberate upon a big policy issue that is, dominating the headlines, that is in the news space, but go beyond the headlines to try and look at what the policy really brings to the table with a panel of experts. So a very good evening and welcome to all our participants as well who are joining in into this webinar, as well as all those who are tuning in into the live stream on our different social media platforms. Now, today, what we're going to talk about is a very important bill that is right now under consultation. It's open for public remarks. This is the Digital Personal Data Protection Bill 2022, which actually has been brought forward by the Ministry of Electronics and Information Technology. Now, this is not the first draft of the bill. The previous bills, the previous avatars have been contentious enough. And this bill is, if you go on to the ministry's website, the MeitY website of the Ministry of Electronics and Information Technology, you can see a PDF that links into this draft bill, and it is open for public remarks. It is likely to be tabled in Parliament around the budget session in February in 2023. Now, this bill is considerably shrunken from the 2019, in fact, draft, which had to be pulled back by the government. We saw the opposition go hammer and tongs at the government, critiquing the bill. So what does the current version really have to offer? Is this a version which is a significant improvement over its previous version? That is key to today's discussions and something that is being debated by different think tanks, by academics, by people, experts who are working, who have their expertise in this area. We will try and deliberate upon all the gray areas as well as the changes that have been made. Because once this bill is legislated into law, what it does seek to is to provide the processing of digital personal data, which supposedly should be in a manner that recognizes both the right of individuals to protect their privacy, to protect their personal data, as well as the need to process personal data for lawful purposes. So to try and take us through what this current avatar of the bill really has to offer for us, I am joined here by Apar Gupta. He's the co-founder and executive director for Internet Freedom Foundation. Thank you, Apar, for joining us.
Thank you for having me.
I also have with me Prashant Sogathan. He's the lawyer and the legal director for Software Freedom Law Center in India. Prashant, welcome to the conversation.
Thanks, Smita, for inviting me.
And last but not the least, I have Dr. Muktesh Chandar, a man who has worn several hats. He has served as the former Special Commissioner, Delhi Police, the former Delhi Traffic Commissioner. He's also been the former director at NCIIPC and has been working extensively on cyber security, on data as well. Thank you so much, Dr. Chandar, for joining us in this conversation.
Thank you, Smita, for inviting me to this discussion.
Thanks. Before I start talking about the red flags and the flaws, what I'm going to do is each of you, if you could take maybe 3-4 minutes and take me through what you find is the most important departure in this bill from the previous version. And then we will come in and talk about the red flags and the concerns. But maybe we could just start by highlighting if something has really significantly changed or not. Prashant, would you like to go ahead with this?
Thanks, Smita. Definitely, quite a lot has been discussed over the years, specifically with respect to data protection. Now, what we need to see is, the Supreme Court of India in this celebrated right to privacy judgment on August 24, 2017, it stressed specifically on the need and the importance to have the right of information privacy. Now, the question is whether this bill meets those what has been held by the Supreme Court. So that, if you look at those, we should. I will come into it the later part of it. But yes, as you said. If you look at the positives, one, of course, one positive that we can say is in a departure from most of the other legislations. This is drafted mostly in simple language, easy to understand for the layman. That definitely is a good thing. But simple language doesn't make it easy for a person to exercise their rights if the rights itself are not clearly in the bill. So that definitely is a problem. Simple language definitely is a positive thing. Then, yes, the provisions of data localization, if you look at it, that definitely is a departure from the earlier versions of the bill. So this makes it easier for, let's say, companies to transact business with other, organizations in other countries, transfer data to their subsidiaries, their companies. So that makes it easy. So from the, let's say, the point of view of a company or a point of view of business, there are good things with the bill. But that also could be a problem because it ticks the right boxes for companies and corporates. When it comes to the rights of citizens, definitely there are a lot to be discussed, which I will discuss subsequently. Then, yes, one positive I would say is with respect to the rights of children, when their data is handled, the specific provisions which prevents profiling, that I think is a positive. Back to you.
Apar, let me come to you, and can I just request the other panelists to keep their audio on mute while we are talking and unmute yourself when we come to you. Apar, your take on what you think is the significant revision to the bill amidst all the, and I read it's on this, the Internet Freedom Foundation's understanding of the bill. Your website does mention that the bill currently has shrunk from almost 90 plus clauses to almost 30 clauses now. So it's a leaner revised bill that we are looking at. But take us through some of the key points that you think have been done right in this version.
So I think what's the standard of comparison, Smita, as Prashant outlined, is not the comparison between a draft which was placed by Justice Sri Krishna and the present avatar, which is the Digital Personal Data Protection Bill. The basis of comparison is the Supreme Court's judgment in case Puttaswamy versus Union of India, because the specific judgment obligates a state to, in fact, make a positive law which actually helps people exercise the right to informational privacy. In fact, Justice Chandrachud states that he hopes that a data protection bill is made in line with the principles outlined in the Justice K.S. Puttaswamy judgment. One of the key cornerstones, and I think the positive which may come out from this data protection bill, which is very imperfect in some respects, even harmful, which we will cover later, is that it still maintains that the bedrock of the informational privacy of a person is that person's consent, which is that they need to be put to notice, and that notice should then have adequate information with respect to their personal information, how it will be gathered, how it will be used, and with whom it will be shared. Of course, the exemptions to that are very, very large. The second thing which I think is positive in this bill is with respect to the rights of the data principal, which is the person who's the beneficiary of the data protection law. And I think here there are some nominal rights which are there in favor of a data principal. This does not depart from global practices because these rights which are created beyond the consent which is offered by a person then offer a person the chance to exercise, for instance, the right to modification and correction, the right to ensure deletion, the right to be safeguarded against data breaches by itself, which comes towards the obligations of what are the data fiduciary, which are the people who gather this information. I think I will stop here because I fail to see further positives with this bill, and I think there's tremendous scope of improvement which remains within it.
Dr. Chandar, not too many positives there, perhaps, that one can count on as far as the opening remarks from our I hear an echo, Dr. Chandar, in your audio. Can you? Yes. Take us through. We are already lagging behind when it comes to data privacy, data protection. This bill should have been like a law like yesterday. Perhaps there are delays in our timeline too. But what would you say would be the essentials for this kind of a bill in terms of strengthening our data protection? How important does that become, Dr. Chandar, in your opening remarks?
So first of all, while agreeing with Prashant and Apar that it's much leaner, very simple, and deviation from the judgment and the principles laid down in the Supreme Court judgment, as well as Sri Krishna Committee. But what is important is that now we are in tune with GDPR. So the data security principles or data protection principles of data minimization, storage limitation, purpose limitation, accuracy, and accountability, all of them have been incorporated into the new act. This is one important thing. Another important thing is the penalty regime. A separate board has been now constituted with wide powers and depending upon the violation or the breach, a graded penalty provision has been given with the adequate scope for appeal. What has not been provided for is that how the board will be constituted, who will be the members, how they will be recruited, what would be their how they can be removed or things like that. But I'm sure they will all follow when the rules under the act would be formed, and maybe some more clarity will come when the bill is laid in the parliament. So this is one important thing. Another important thing is now there are two types of data fiduciary. One is the normal, the other is significant data fiduciary. So anyone who is dealing with a large amount of data, they will have additional burdens on them to safeguard the data. The other important provision which has been laid down is that there is an alternate dispute resolution mechanism which has been separately laid out here. So I'm sure many more things will come up in the bill, and I would definitely say that this was much needed. We have already got delayed, and because of the concern of several companies about the data localization. Now that data localization has been given in such a manner that the central government can decide where the data can go and where it will not go. So it will depend on so many factors, and also depending upon the political relationships of a particular country with us.
Okay, we will follow up on the points that you've made. Apar, coming to you, what Dr. Chandra just said is that this seems to be in tune with GDPR, or the General Data Protection Regulations adopted by the European Union. Would you agree to that? How does that really compare?
I think the inspiration for this law seems to be fairly indigenous beyond certain core characteristics which are there, for instance, of consent. Because even when you look at consent, there is a provision called deemed consent. And if you look at the definition of personal data, then there's no definition of sensitive personal data. So there are significant deviations, in fact, from the GDPR. In fact, even for industry bodies, they are saying that there's an omission of a provision with respect to when the bill comes into effect with the GDPR after notification as a regulation came into effect after 2 years. And the instant bill only specifies the power of the central government to notify when the different provisions of the act will come into force. I think some other significant deviations which one needs to notice and recognize is that there's firstly, there are duties on data principles. That's not present in the GDPR. And these duties, for instance, of ensuring that a person's information is accurate with a data fiduciary, that we need to provide our complete details, and that can be actually resulting in a fine of up to 2,000 rupees as a penalty placed on a data principle, which is us, is very novel. It's onerous. It's not there, in fact, not only in the GDPR, but in several legislations. It's like, if you do a comparative search, it's not there. With respect to the exceptions, for instance, the government has the power under possibly without any criteria, for instance, just with respect to the volume and the nature of data, which is mentioned in the provision for exceptions, to notify a data fiduciary or a class of data fiduciaries from the application of this law, which means that it can even be a private individual company from the exception of from the application of this law, which means in effect that the entire law can be essentially exempted from A company or B company. That's not under the GDPR. And finally, the Data Protection Board, which is there, is not a regulatory body in a sense. It is essentially an adjudicatory body which may be given additional functions. It does not do any standard setting. And the Shri Krishna draft, which is the previous draft version of a data protection proposal in India, in fact, created or proposed the creation of a data protection authority. And if you look at the GDPR, it required national governments within Europe to create either the office of a privacy commissioner or data protection authority, which could come out with regulations on the enforcement of the law. And this power is not there with the data protection board. All the data protection board can do is resolve complaints which are filed by data principals like us, or any additional functions which may be prescribed by the central government. Finally, I'd just like to end with this. This law centralizes a large amount of control and power with the central government, with rulemaking power, which is not guided by any kind of ingredients or any kind of specific criteria which is laid down in the legislation. It's very vague. It gives a lot of power to the central government and none for the state governments whatsoever.
Okay, Prashant, if you could come in on the points that have been raised by Apar here, because I'm also reading, some of the takes by other think tanks as well, including Carnegie India, and they do seem to suggest that when Apar is talking about the Data Protection Authority, as was mentioned in the Sri Krishna Committee version, and now you're talking about the Data Protection Board, they seem to suggest that this is likely to improve regulatory certainty and provides a better balance between enshrining data privacy requirements on one hand and allowing the economic use of personal data on the other. And this is, of course, from their reading of the bill. Your thoughts on this, Prashant?
Yes. Smita, when we initially mentioned the privacy judgment, the case Puttaswamy judgment, the Supreme Court categorically held that when the government comes out with a data protection law, it requires a careful and sensitive balance between individual interests and legitimate concerns of the state. The current draft, what is put for consultation, does this comply with the principles laid out? I'm not sure. I'm afraid that it doesn't. I would say what my answer be. Now, if you look at the judgment as such, it laid out a three-part test, three specific aspects to be considered. When there is a violation of or infringement of the privacy rights of a person, which is permitted, what could that be like? So the first condition was there should be a law in place. Yes, now you have a draft law. Once it is enacted, you will have a law in place. So the second one was there should be a reason for any violation, that it should be reasonable, that there should not be any arbitrariness. The third one was that proportionality test. Now, the question is, if you look at the various clauses, like which Apar mentioned, does this satisfy the test laid down by the Supreme Court? If you look at the kind of concentration of powers on the central government, I would say this goes beyond that. These are definitely not reasonable. These are definitely not proportionate at all, is what I would say. The kind of powers which are given. And even if you look at the Data Protection Authority, when this was before the Joint Parliamentary Committee, there were a lot of discussions about the composition of the selection committee. Now, all that is done away with. Now we have to have the entire power to the government to come up with a board. Earlier, it was an authority. Now it's a board. And what about the composition? What about the selection? Nothing. The bill does not say anything about this at all. And all these powers have been vested with the central government. So that is beyond, if you look at any act for that matter, which, not specific to data protection, any act, when there is a formation of a board, an authority, etc., it will be clearly laid out as to how the constitution will. How will the selection happen? What are the criteria of the people who could be part of this, who are members of the government, or members of such an authority? Now, this law doesn't say anything at all. Everything is left to the executive to decide. So that definitely is a problem. So when there's a lot of power given to such a board, it says there are other powers that should be given. Yes, even if it is adjudicatory in nature, as Abba pointed out. How will this function? What will be the composition? These are all matters left to the government. Same with issues like deemed consent, where again, there's a lot of powers given to the central government, also for exemptions. So that definitely is a problem. The vast exemptions, vast powers given to the central government in the Act definitely is an issue.
Okay, before I go to Dr. Muktesh Chandar, can I request all our participants who are a part of this webinar to go ahead and post your questions for whoever it is intended to in our chat box. Our chat box is now open. I will start taking in your questions too. And those who are watching it on Twitter, Facebook, YouTube, leave your comments there. We will accommodate it during the conversation as well. Dr. Muktesh Chandar, taking forward what Prashant and Apar have now argued, because that seems to be the strongest critique of this revised version 2, that this gives a blanket exemption to central investigating agencies on grounds of security concerns. Your thoughts, sir?
See, every act, whether maintenance of law and order or even in IT Act, in the national interest, certain exemptions are always provided. And they include sovereignty of the state, maintenance of the public order, friendly relationships with various countries. And this is a established principle of governance, that certain exemptions which fall into exceptional categories are provided. So I think they have been provided here also, and there is nothing unusual about it. It's part of the system. It has always been there.
Is it always been there, Apar?
Like to just clear up one conceptual point. The application of the data protection law right now is to classes of data or classes of activity in which data is gathered through consent, not surveillance. Surveillance is out of the picture here. So we had a proposal from 2011 to 2014, which was called the Privacy Bill, which was led by the Department of Personnel and DOPP. And that had not only data protection, but surveillance reform as well. So the present version is only looking at instances where the government asks you for data with your knowledge, not when it's surveilling you by itself. For instance, it suspects that you're committing a crime or there are issues of national interest. Now, I do understand that even in categories where your data is consensually gathered, the government has a legitimate interest for pursuing activities in which it may need to go over your consent. For instance, it's gathered data only for a specific purpose, but it needs to go over and above that. And that is constitutionally consistent, but you need to abide by the standards as Prashant outlined under the Puttaswamy judgment. For instance, one standard which he said was proportionality. What does proportionality mean? It means that if your national security interest is to ensure that X activity does not take place, you will essentially only surveil Y people who may be suspected as being people who can do X activity. It will not be Y plus 2,000 people, right? So that's proportionality. But when one looks at the exemptions clause, which is clause 18.2, under clause 18.4, much more specifically, all state agencies are exempted from the general obligation of data fiduciaries to limit retention of data after the purpose of data collection is fulfilled, which means even a municipal department, the MCD in Delhi, if it gathers your data for essentially ensuring that there's proper pipe connection, but you shift to another city, you will not have the ability of asking them for deletion of your data because you're not availing any municipal services in Delhi by itself. So what I'm saying is that this law, the way it is being proposed and drafted right now, is contrary to the Puttaswamy standards, and it is not as if the legitimate state security interests which may be arising are being hampered if those proportionality standards are met in any instance.
Okay, we have a question which is linked in a contrary sort of a way. Dipankar Khashnavish is actually asking, given its nature, can states really have any power which it can exercise on its own in the context of data? Would you like to come in on this, Prashant? And I would like to Dr. Muktesh Chandar also to comment on this. Prashant, unmute yourself, please. Prashant, you'll have to unmute yourself.
Yeah, sorry. Okay, so with respect to the, let's say the power of states as such, I mean, I believe he mentions the states as a country. So See, when it comes to, let's say, the power of the governments, various governments, definitely when it comes to issues like security, there can be some, let's say, violation of privacy. In the sense, there can be some curtailment of rights. If you look at the privacy judgment, the judgment provides for that there definitely can be some kind of control. But even then, like Abba was mentioning earlier, whatever rights you exercise, whatever powers that you exercise, that should be in conformance with the proportionality principle. That the states definitely have some power. That doesn't mean it has kind of power which is beyond everything, which can go to any extent. The powers that you exercise by the state should definitely be proportionate and in tune with what's the legitimate aim. So that is a problem if you look at the bill.
Dr. Muktesh Chandar, your thoughts?
See, when we're talking about the proportionality, every law under which these things are done, there are sufficient safeguards and oversight mechanism. Now, in IT Act also, a lot of such details are there in the rules. So I'm sure we'll have to wait till the rules are framed in this regard, and then the proportionality, where the privacy of an individual as well as the safeguards for the national interest as well as public interest, they will be taken care of.
So, but, you don't think that the kind of guidance that we are talking about, which should have been laid down in the parent bill itself, that is lacking?
No. I think in IT Act also the details are given in the rules regarding data interception. The clause is there in the main IT Act, but the details are there in the rules. In the same way, under telephone interception, the main act, Indian Telegraph Act, the details are there in separately laid out in the rules.
But the devil is always in the details, apart. Professor Kashinath Mishra is asking, do you feel the ruling government can take advantage of these laws where private information can be monitored?
So I'll not say the ruling government. I will say governments. And this is important for us to understand as citizens of this country. Governments will come and go, but quite often the mechanisms which are established, right? They, over a period of time in a rule of law society where India does not have the best of rule of law, let us also acknowledge that, right? That is the experience of the common person when they interact with public authorities, when they go to courts. There are so many complaints, right? So we do know that we don't have the best rule of law system. We have to account for the aggregation of power through proper mechanisms and safeguards. And one learning which has come through over a period of time, as imperfect as regulatory bodies are, once they are autonomously established and their function of that ministerial level is separated to a much more professionally tasked autonomous body like a data protection authority to lay down regulations, to lay down standards, to give exemptions by itself. The political lobbying which happens at the ministerial level with their political interest as well as their governance interest does not intersect together. I think this is very important, and I'll come back to one example. For instance, the exemptions which are provided. Now, if you look at the exemptions under clause 18.3, the central government, which means the Ministry of Electronics and IT, may by notification having regard to the volume and nature. Volume is also not defined. It may be high volume or low volume. The nature is also not defined. It may be sensitive. It may be ordinary. Or personal data process may notify certain data fiduciaries or class of data fiduciaries as a data fiduciary to whom provisions of such and such sections of this act shall not apply. Now, what does this mean? The central government, let's break it down. The central government essentially will act through the business of allocation rules through a specific nodal ministry, that is the Ministry of Electronics and Information Technology. What has been our experience over the past 1 to 2 years in public consultations, as well as other engagements with the ministry, has been it is usually not well resourced and staffed. And this shows in budgetary allocations, for instance, where it has not been given its due share of money. It doesn't have the proper resources to even do policy setting at the top level. Now, if we are expecting such a ministry, let us acknowledge with good faith, right? If it needs to exempt a class or a specific data fiduciary from the application of this law, how will it be done when it does not have the expertise? Will it not be susceptible to capture? Will it be able to do its job properly? So I'm saying, let us dispense even with bad faith arguments. Even with good faith, what we need is an independent regulatory body, and usually bills have a financial memorandum in which a regulatory body is to be created. They say that they need so many 100 crores for its establishment, for it to continue its work. However, under this bill, the Data Protection Board, which is an adjudicatory body, most possibly will not even have a physical office, will only be a techno-legal body by itself. For instance, it will just do its work over Zoom calls. So what can we expect in terms of enforcement? Which is why I think this law may not only fail due to surveillance or due to capture of power. It may fail because it may not actually give remedy to individuals against both public authorities as well as large private corporations.
Dr. Chandar, come in on this, because you have also seen how the government works from within the government. You've operated, within ministries and departments. APAR is raising some very crucial issues here. Even if we were to believe that this is not a step towards MeitY becoming the judge, jury, and executioner, but there are inherent capacity challenges here that he is raising our concerns towards. Would you find them valid? How do you get over these structural, in fact, issues too?
See, I would say that we are trying to read too many things between the lines which are not there actually. The spirit of the act has to be seen, and in every such system, there are sufficient safeguards. The safeguards have to be built into the rules which are a part of subordinate legislation. They are also laid on the table of the parliament. So all those things will take place. We are I think interpreting things too early.
Prashant, would you agree with that? Or, when you talk about, say, for instance, what fills the void if the Section 43 of the IT Act is scrapped off? Or in terms of the guidance, are they vague? Or are we reading too much in the spirit of the act is what we need to read into, as Dr. Chandar says? Is there enough scrutiny that is going, assured that will happen even through a parliamentary process?
I mean, I would definitely say that the provisions are such a very vague. And gives a lot of power to the central government to come out with rules and regulations. Now, you specifically asked about 43A. That definitely is a major issue. If you look at the provisions of this law, it provides for, let's say, levy of fines on corporate bodies. But what 43A did in the IT Act is, if there is a problem, there is a harm caused to an individual, a loss caused, or a gain caused to someone, then you could approach an adjudicating officer. And this, the data principal, that case could be compensated. But here it's all about the fines. But how will I benefit? For example, if my data is breached, when a loss is caused to me, who will take care of that? It doesn't help me if the company is fined. What about my loss? Who is going to take care of that? The Act doesn't answer that question. It only talks about fines. Who is going to take care of the loss suffered by the person, by the citizen? Now, again, if you look at the definition of public interest, it's very interesting, in fact. The deemed consent provides for public interest. Now, in public interest, yes, security of the state, all that. I mean, those are exceptions provided in Article 92, which you will find in most of the rules, even in the IT Act. The rules under the IT Act will do have such clauses. But here, it also has a clause which talks about misinformation. So to prevent, let's say, spreading of misinformation, that also is a clause for public interest. Then, this is something unbelievable. It talks about mergers and acquisition of companies. How is that public interest? If a company is merged, how is that in public interest to, let's say, to treat something, the data that I provided to company to be a deemed consent? How can a merger and acquisition or a corporate restructure be considered to be public interest? But that's what the Act says. That's what the bill says. So,
Dr. Yes.
Yeah. So, I mean,
please
such wide definitions, such wide powers definitely is a problem.
Dr. Chandra, your thoughts? I mean, what Prashant is raising, that even in terms of corporate mergers and restructuring, how are you looking at it from the public perspective?
First, let me come to the Section 43A. I agree that the compensation part, which was earlier available and now it will be scrapped, that will be missing. But I'm not sure whether the board would have the power to pay a part of the penalty imposed on the data fiduciary to go to the data principal who's interests have been harmed. In fact, the courts already have this power where they levy a fine, and a part of that is given to the victim, whether it is laid down in the criminal procedure code or not. So that provision may take place, but I would agree that this could have been included specifically as a part of the new bill. The second part is the merger. For example, now suppose I am a shareholder of a company A, and tomorrow the company A and B merge together. So all my data will have to go to the company which is formed after the merger. So what is the problem in that?
Prashant?
See, the problem is we were talking about consent. So when a merger happens, see, there is a consent that I have given, but maybe I don't want my data to go to the next entity. I'm not talking about being a shareholder, but a company could be having a lot of information. For example, a social media organization. It will be having a lot of information about me. So what if it goes to another entity, maybe located in another country even? Should I have some control over my data which is being transferred? Can that be treated to be deemed consent in any way?
Apar, would you like to come in on this?
So I think the first, let's start with how the phrase public interest is defined, because if you look at deemed consent, which is clause 8 and says deemed consent, subclause 8 says that deemed consent includes in public interest, including for. So it's an illustrative list. It's not an exhaustive list. That's the first thing I'd like to just put out. Okay. So it can also be things which can be prescribed at a later point in time, right? And a lot of this prescription which will be done by the central government under rules which are made by. I'm going back to what I said earlier. Usually these are functions which are played by an expert body, and we've seen expert bodies in domains of capital markets, which is SEBI, or in terms of monetary finance, which is the RBI. Or we are also seeing that in other spaces as well. What it gives it is expertise, knowledge, and the ability of taking its decisions with autonomy without a level of the appearance, at the very least, of any kind of political interest influencing its decision making. So I would say that even in terms of when mergers are done, in which consent, which may be given for A purpose to A company, is being taken over by B, that should not be automatic by itself. A person should be at least put to notice. They should have the ability to opt out. And in case there is disagreement with that, it should at least be notified to a regulatory body which is independently established. I do understand there are business concerns which come into play regarding this. But we must also understand that for the operation of a data protection law, which we have resisted for such a large period of time, it has led to all kinds of outcomes which have individually then harmed a lot of Indians. For instance, we suffer from a huge amount of spam calls every day. That's because our information is out there in the public. They know about which banks we go to, when we purchase a car, what services we avail. And think about it also from the perspective of law enforcement, which is consistently now saying that cyber frauds in India are rising to a very high level. Cyber frauds at its very root happen quite often because of social engineering, which is a large category of how a person can attack an unsuspecting victim on the basis of knowing a little bit about them or gathering more of their information, and thereby bypass the traditional technical security mechanisms which are in place. These are much more tangible harms which result when we allow a large proliferation of data without having consent, adequate regulatory oversight. And of course, there can be exemptions provided in certain cases which are there, but they need to be proportional. You can't give data protection with one hand and take it back with two.
That's right. Dr. Chandar, Apar there is raising important points, and cybersecurity is again an area that you've been working on. Do you think that there are enough safeguards to what Apar says, that there is this proliferation of data, which can also then lead to cyber fraud? Is that kind of a safeguard there that you feel?
See, It's a known fact that a lot of information of individuals is available in public domain. It is available for sale illegally, I would say. And then, of course, a lot of spam calls and SMS messages are coming up. There are mechanisms available in the law. The implementation of particular law, how on the ground per se would not make that law faulty. For example, let us say murder. The entire mechanism is there to deal with murder, but still murders do take place, and they have been taking place, and they will continue to take place. That does not mean that Indian Penal Code is faulty or the Criminal Procedure Code is faulty, but there are gaps in the implementation part of it. And I'm sure with this act also, things will be taken care of to a large extent. And as we slowly learn, more and more things will happen. For example, this spam call. I'm personally a victim of that. Every day I get about one or two mails or SMS or voice calls, and I have been raising this issue with Telecom Regulatory Authority. DND provisions are there, but still they take place. So it's a continuous improvement over the mechanism which are existing. If there is a shortfall, we improve upon it.
So, but I think, there is a bigger problem that is emerging from somewhere, a lack of, an erosion of trust. Like, for instance, we have a question here from somebody who hasn't named themselves, which says, how does this draft take the consideration of a data being collected by government agencies? And are there any indications, chances that it might affect our electoral outcomes? These are questions when, nobody is saying that there are not enough provisions laid down within the law. But is there any guarantee that the law is not being misused? If there is a case of overreach by the government agencies, then what is the question? Then what is the safeguard?
No, I think I would say that we're trying to see a ghost which is not there. These are concerns like electoral manipulation. This is not possible. There is a system, there is a entire mechanism available. How that thing can be connected here? I think we are being too much speculative on this issue and raising concerns which are not genuinely there. The act is to be passed. There are more provisions which might be added. There will be rules framed under the democratic process of our country. And I think that is the time we may say that something which is not functioning the way it should have been. Right now, it is too early and too premature to make these comments.
Or maybe because the consultation process is on, that's why it's better to come out with these apprehensions right now. Because, the National Campaign for People's Right to Information, which is led by prominent activists like Anjali Bhardwaj, they recently, in fact, did a webinar where former Chief Central Information Commissioners came together. And in fact, in a statement released, and I'm reading from that statement, they say that this is the amendments proposed to the RTI Act 2005 through the DPB will severely restrict the scope of the RTI Act and adversely impact the ability of people to access information. Apar and Prashant, I want both of you to come in and weigh in. Is there as Dr. Chandar says, that there are ghosts that we are seeing? Or are these exaggerated fears? Or are these genuine concerns when it comes to violation of citizens' rights, human rights issues? Both of you. Apar, if you could start with.
So I think what NCPRI, Anjali, Amrita, Nikhil, they are pointing to is that the right to information is one of the most cherished rights for every Indian. I think it's brought about a high degree of accountability in public life. It's improved it certainly, and it means a lot for people who are poor actually. It means that they sometimes are able to get their rations, they're able to get the civic services, which sometimes only are done on paper. It's not actually delivered to them. And I do think that one thing which they have encountered over a period of time has been the difficulty with getting information sometimes under the RTI Act, because it's refused under a section called Section 81J. It's not like it's perfect. Because it's related to the privacy of a third party, and then the bodies which are constituted in the RTI Act have to determine whether the private information which may be released of a third party actually is justifiable in public interest. So the larger ground under which it will be determined is public interest, but privacy will be a part. So there has been some friction with regard to the right to privacy with regard to this. But when the data protection bill was being drafted about 3-4 years ago, even during the Sri Krishna process, both people from the data protection and privacy communities and the right to information communities essentially put out a joint statement in which said that information quite often is power for the individual, and it needs to be in favor of every ordinary Indian. It shouldn't be in favor of the government. And it plays out in a privacy context in the sense that the government should not be able to surveil individual without clear legal standards which are justifiable and constitutional, and at the same point in time needs to be accountable in providing information. Now, what has happened under the Digital Data Protection Bill is a proposal to delete Section 81J as well as this proviso. And as per a joint statement, which I have also signed, they explain it very well. They say that the draft which will seeks to create a legal framework for the governing of personal digital data undermines by proposing amendments to Section 81J of the Right to Information Act. In Section 30 of the draft bill, Section 81J of the RTI law contains within it privacy protections which have settled provisions of law, while the proposed amendments render both the right to privacy and the RTI ineffective. Through this amendment, all personal information can be denied even if disclosure of the information is relevant to the larger public authority or in public interest as provided for in Section 8 of the RTI Act. It unjustifiably removes the proviso to Section 8. It goes on. You can read this joint statement, and it's not only these activists. It's co-signed by 3 judges, one of the Supreme Court, 2 of the High Courts. And I think it's really important because if you look at the explanatory note behind why this law has been brought, or when Minister Vaishnav says why we have made it simple for the ordinary Indian to understand, or why we have used the word she, we have phrased it in a feminine phrase, and all of these are signaling innovations towards essentially a much more transactional sense of how every ordinary Indian will enjoy a right, will enjoy a remedy, is that every ordinary Indian also files RTIs. I know many people who file RTIs who are not RTI activists, in fact, who file it to get work done in their colonies, or get pensions or get the right kind of social benefits. So I think this does need more considered thought by the Ministry of Electronics and IT during this consultation process.
Prashant, your thoughts on this issue in particular, on how it impinges upon the RTI Act and the kind of safety net that should be there for those individuals?
Yes. See, even if you look at the GDPR, there has been discussions about the friction between right to be forgotten, the privacy rights and free speech rights. So definitely that there has to be a balance between these two rights. It cannot be that your privacy rights will be over all the other rights. So the right to information, the right to access information of citizens, that right is also very important. In the name of privacy, you cannot, let's say, destroy all these rights. So there has to be a careful balance. As Sabha rightly said, definitely right to information is a cherished right to citizens. The rights which helps not just, let's say, activists, but also a lot of other people to get a lot of information to make sure that maybe in many cases even where the grievances are addressed because they filed RTI requests. So you cannot take away those rights, just by citing your privacy or data protection principle. So that definitely is important. And also the question about elections and how this could affect electoral outcomes and things like that. So, there were litigations before the Madras High Court on this issue, when the allegation was that the data collected by the government, either using Aadhaar or various other schemes, were used for elections and campaigning. So when such allegations are made, definitely we need to be very careful about the kind of data collected by government agencies, the kind of people who get access to such data. And that is where the problem with wide exceptions to this will, that also should be addressed. So when you have such huge amounts of data being collected by government agencies, there should also be controls on how this data can be used. Again, one problem, there were, if you look, if you are often comparing our law with GDPR. GDPR, there's a specific provision which prevents profiling, especially with respect to electioneering and things like that, which is absent in this legislation. So we definitely need such safeguards in place. Dr. Buktesh was talking about safeguards, but safeguards have to be built also into the Parent Act. That they cannot just come in the rules. It should be there in the Parent Act, which ensures that the rights of citizens are protected. So that is something which the parliamentarians have to debate and come up.
I mean, if former chief information commissioners are coming together, if former Supreme Court justices are coming together, prominent social activists are coming together, clearly it's not just about seeing ghosts. I mean, these red flags do have some grounds. And, again, one of our audience members, Dipankar, is writing that the government has been accused of violating personal data like this. So what is a safeguard that you think should come into it to assuage these fears right now? Because this is a stage where the discussion is happening. And clearly, as Prashant is also reiterating, that the safeguards need to be built into the Parent Act itself. It cannot be left in for an afterthought or for a revision. Dr. Chandar.
No, I'll still stick to the view that all the details will be there in the rules which are framed under this, and this has been the procedure we have been seeing, and still there is a time to raise suggestions and objections, and I'm sure the points being raised will be considered.
You don't see this impinging on the RTI Act currently in its current version?
No, I have not seen what he was talking about. The earlier speaker was talking about some petition or something, some signatory to that. I have not, therefore, I would not be able to make any comment on that.
Okay. But Apar, just also the other thing that I would like you to explain to our audience, because we have the last couple of minutes, when we say that this new bill acknowledges the withdraw consent that recognizes the right of a person to post-mortem privacy, your thoughts on if this is a step in the right direction?
Certainly, it's a step in the right direction, I would say. A lot of people are building a lot of their lives online. A lot of it is connected to their personal data, and a statutory recognition of it in terms of their being permitted to then assign it to a person after their demise is something which will certainly be of value. I think, though, that succession laws are aging quite well in this respect. It's not as if what this law does is wholly novel, given that in several petitions before several courts, succession has also been done with respect to certain other things, including digital accounts for people. So it's not as if it's completely something which is out of the ordinary, but I think it does make things easier. It does provide that kind of comfort. And I do think that's a step in the right direction.
Prashant, would you like to come in on this?
Yeah, I fully agree with Abbar. Definitely, this is a step in the right direction. So, specifically in case where a person passes away, then his legal heirs obviously should have right to access his data. And, whatever rights that this person has, they should flow to his legal heir. One problem is that it specifically talks about a nomination. The question is, what happens if there is no nomination? So maybe if the data protection authority or the board right now, maybe they could decide on such questions. Maybe if somebody does not nominate a person, what happens? Can a legal heir then approach the board and then request for such data to be removed, deleted, etc.?
Okay, just the last comments that I would like to take from all of you. In fact, on cross-border data flows, Prashant, do you think that it's a softer stand on data localization requirements? Is this a needed softer stand?
I definitely think it's a welcome move. If you look at the kind of stricter provisions that were the previous drafts, definitely from the point of view of the industry, it's a good thing. But then the question specifically with respect to kind of countries, it can be the data can be transferred, which is decided by the central government. If there is some guidance on those, I think that would be better.
Apar, your concluding remarks in terms of the key points that you think the government needs to put into this.
Actually, I vary quite substantially from this baseline. I think that we had invested about 3 years of institutional work, both as members of civil society, academics, experts, think tanks, but more importantly, the government. The Ministry of Electronics and IT constituted an expert committee, the Justice Sri Krishna Committee. The Justice Sri Krishna Committee deliberated, held public consultations in person in different Indian cities. I'm recapping this because this was all public money which was spent. There was so much energy which was spent. There was a law which was sent to Parliament. Parliament constituted a JPC. A JPC, in fact, proposed several amendments and said, pass this law with these amendments. And even as much as we were dissatisfied with some of those amendments, I think that law was still in better shape than what we have in front of us. I think what's prudent for us is to recognize that that kind of institutional deliberation resulted in something which is quantifiably better than what we have in front of us. It may be much more complex, but that does not mean that a simple sentence is better. For instance, great works of literature do run into hundreds of pages, but that does not mean by itself that they are not great or they are not good. So
are you suggesting, Apar, that this version should be also withdrawn and actually the last version be brought in?
Exactly. And just put it through a Puttaswamy analysis. Please get a legal opinion on the Puttaswamy analysis from the Ministry of Law and Justice, not from people like me who may be perpetual critics, never satisfied because we have civil society. But put it through a Puttaswamy analysis, ask an opinion from the Ministry of Law and Justice on the last draft by the JPC, and please put it before Parliament and pass it at the earliest.
Prashant, is the last version actually looking a lesser devil comparatively?
See what as Abha rightly said, that has gone through a lot of iterations. There was this initially, so start with the Justice A. Shah committee, then we had Justice Sri Krishna. So there were a lot of deliberations which took place. Now you can't throw away all this, scrap everything and then come out with you just because it's maybe in simple words or a shorter version of the bill. A shorter version does not always make it nicer or better. So definitely, if you look at the JPC report, it's a very lengthy report, looks into various aspects. So there are a lot to learn from this, from these deliberations which happen over a period of time. Let's not, let's say, do away with all those recommendations. Let's not do away with all those deliberations, consultations which happen, and then start afresh. That doesn't serve the purpose. What about all these years of work? And I fully agree with Abha on this. Definitely the previous version was much better. Yes, we of course had our disagreements, comments about the previous version also, but I would say this shorter version does not, I would say it's not a rights respecting framework. That's something very important.
Okay. Dr. Chandra, your final remarks, sir. Do you think that this was absolutely necessary to do away with all those years of deliberations that went into the 2019 bill?
I think there is no point in discussing this now. The new bill is there and it will be deliberated upon and it will be, I'm sure, passed. So why, there are so many reasons behind it, why the earlier bill was scrapped and why a new version has come up. But I would like to mention something about the data localization relaxations. This is definitely a very welcome step, particularly in the context of startups and small companies, which will definitely benefit out of it. And the central government will have a lot of factors into its mind before giving permission for a particular country or territory where the data can go, depending upon the data security, cyber security posture of that particular country or our relationships with them. And those, there could be many factors, geopolitical situations, etc. So I think that would be a definite step, and let us wait for the bill to be introduced in the parliament. There is still time for suggestions and objections to be put in. I'm sure many of these points which have been discussed today would be part of that. And after deliberations are done in the Parliament and through the process, a better version would emerge out of the whole exercise.
Okay, we will leave it there, of course, but as Apar and Prashant do seem to mention here that at the moment, perhaps the 2019 version looks better. Of course, there has been serious concerns that have been raised. There are also, remember, let's not forget, there are deliberations ongoing, petitions ongoing when it comes to social media giant WhatsApp's privacy policy in India, which will be watched very, very closely by the lawmakers too, by the executive too. But there are serious concerns and red flags here. And I think when you throw away entire years of deliberation, then this new process of public consultation, well, we are not going to have the 2019 version back, as Dr. Mukesh Chandra says, that is very clear. But when you have this completely new version out there, perhaps we'll have to wait and watch as to now really what can kind of emerge out of this. And we can only hope that, that there is more acceptance, a greater acceptance of the critiques that are coming in at this stage. But appreciate all of you joining us here on Let's Talk Policy, as well as to all our audience who joined in and tuned into this conversation. Thank you so much.
Thanks, Smita.